Hello everyone, and as you know, I'm analyzing the question paper of Forest Ranger of 2023 question paper. Now, the question number 5, which will appear on the screen, is: as per the provision laid down in the Constitution of India, all persons are equally entitled to freedom of conscience and right to freely profess, practice, and propagate religion. Which article in the Constitution grants these rights? Now, the correct answer to this particular question is Article 25. So, what it does, it entitles freedom of conscience and propagate, profess, and practice religions. Now, as I'm analyzing this question, let's move to the second article. What is second article? Second article is article number 21. What is there? Right to live. Right to live is the second article. Article 21. What is article 30? Article 30 is right of a minority, right of minorities rather, to establish religious institutions, educational institutions. Now, what is the last? Last is Article 31. Article 31. Article, is it visible? Yes, it is visible. Article 31 is right to property. Right to property. So these are the basic things of this question about articles. As this question is basically from Constitution of India, I like to go deep into the Constitution of India. For example, what is Constitution? What is Constitution of any country? I'm not saying particularly about India, but what is Constitution? What do you mean by? What is the definition of Constitution? Now, what is Constitution? Constitution is a supreme law laid for supreme law laid for number one, framework of government. What is framework of government? That means it will contain what are the specific things a government should do, what they should not do. Now, what is the second? Second is distribution of power. How the power will be distributed. For example, the powers are distributed into legislature. What is legislatures? Legislatures who make laws. What is enforcer? Executive who enforce the law को लागू करना, that means enforcer. For example, police, SP office, etc. Now, what is the judiciary? Judiciary is application of law. Is the law have been applied correctly or not? This is an independent body. So executive will not interfere in the legislative section. The executive cannot interfere in the judiciary aspect, and judiciary cannot interfere with the executive section. I'm giving an example. Suppose the police, after investigation, arrest a particular person and forward it to the court with some sections. Then judiciary have a power if there is a procedure lapse in executing or arresting a particular individual, he will be released on bail. That is judiciary. That is the work of judiciary, to look if the executive is doing their work properly or not. Now, come to the Constitution of India. Now, the Constitution of India, as you know the definition of Constitution now, the Constitution of India also plays the same role. Now, when the Constitution was adopted, it was adopted in 26 November 1949, and when it was enforced in 26 January 1950. So in competitive examination, this question will not come, but still most of the people or aspirants makes a mistake. They feel like this is the adoption date of the Constitution. It's wrong. When it is adopted in 26 November 1949, it is known as Constitution Day. Constitution Day. And when enforced, it is known as Republic Day, which we celebrate Republic Day. Now, is the Constitution was changed after adoption? Yes, Constitution was amended. Who amends the Constitution? The Parliament, the legislature. When it was amended many times, but important amendments are 7th, 42nd, 44, 73, 70, 74, 97, 101. These are the important amendments in the history of the Constitution. Now, which is the most important is 42. 42nd Amendment is the most important for competition exam point of view. Now, what is 42nd Amendment is also known as mini constitution. Mini constitution. Why mini constitution? The government at that time was in majority, so they tried to change the constitutional framework. Now, what they changed? They changed the curtailed power of judiciary. And one more point, they also increase the power of the Parliament, who makes law. Increase the power of Parliament. Now, who was the president? Who was the prime minister at the time? The prime minister was Indira Gandhi. Indira Gandhi. So, after a few years, the amendments which were made in the 42nd Amendment were revisited, and they are again the earlier provisions were installed. How they are installed? One of the important judgment plays a very important role. What is the judgment? Kesavananda Bharati. This judgment. Now, before going to this judgment, I like to give a brief information about earlier aspect, what was happening. After the independence, the government of India have decided to abolish the Jamindari system. Now, if you ask me what is Jamindari system? Jamindari system is a system in which the British have initiated. They have said that a plot of land will be given to a Jamindar. And he will engage farmers and who will work for him and produce goods, produce wheat, pulses, everything. And certain portion amount of this production will be given by this jamindar to the British government as a form of a tax. Now, at that time, the government of India wanted to abolish this jamindari system and wanted to distribute this plot of land to the poor people, to poor farmers. Now, at that time, the right to property became a fundamental right. Now, after that, Keshav Nandan Bharati appealed in the Supreme Court. He was a priest, by the way. He was a priest. He owned a property in which there was a temple. Where it was? It was in Kerala. Now, what he did, he appealed to the Supreme Court, who is known as a guardian of the Constitution, that it is a violation of my right, my fundamental right. Which right? Is right to property. Then there was a collision between the Parliament and the Constitution. The Parliament says that we can amend the Constitution of a country, whereas the Constitution itself says that a constitution cannot be changed. The framework of the Constitution cannot be changed. How? A judgment was given by the Supreme Court earlier, Golaknath versus Punjab, State of Punjab. Now the Supreme Court decided. They took a long time. The Supreme Court of India had to decide a certain point. Is there a violation of law or violation of Constitution to amend the framework of it, or the Parliament can amend it? Now it took around 68 hearings, and there was a bench of judges of 13 judges. Then the result was in the ratio of 7:6. And 7 judges have one opinion, and the 6 judges of the 13 judge have a different opinion. What they said? They said that the Parliament of a country, the Parliament of India, can amend it. The Parliament of India can amend it under the provision article of 368. Under the article of 368, the Parliament of India can amend the Constitution. But there's a point that they cannot change the structure of the Constitution. So what are the structure of the Constitution? Structure of the Constitution is supremacy of the Constitution. They cannot change the supremacy of Constitution. They cannot change the rule of law. The law will be everyone will be ruled according to the law which is mentioned in the Constitution. The next is judicial review. The judiciary can review every bill has been passed, every bill which has been changed to law. Sixth is federalism. There is 2 powers. Secularism means every religion will be given equal opportunity in every aspects. Now separation of powers, there will be separation of powers between the state and the center, and the last is democracy. Democracy for the people, by the people. So even though Kesavananda did not win the thing, that did not win his case, but it was a major turnout in the Constitution of India. The Supreme Court said that yes, the Parliament can amend the Constitution of India, but under the Article of 368, but it cannot change the structure of the Constitution. What are the structure? These are the structure of the Constitution: the supremacy of the Constitution, rule of the law, judicial review, federalism, secularism, separation of powers, and democracy. Now let's move to the next section, is the salient features of the Constitution. What are the characteristics of the Constitution? See, the question number 5 is a simple question. Since it touches the Constitution of India, I like to make sure that every aspect of the Constitution is being touched. It will take time, but I will do it. Now, what are the first salient features? Is lengthiest, Lengthest. Is it the correct example? Yeah, lengthiest. Lengthiest Constitution. Lengthiest constitution, written constitution. What do you mean? There are two types of constitution. First is written constitution and second is unwritten constitution. What is an example of the written constitution? Written constitution is Indian constitution is a written constitution. One more example, American constitution is a written constitution. Now what is unwritten constitution? Unwritten constitution is a British constitution which is unwritten. Now, it is the lengthiest constitution, written constitution of the world. There's a question, which is the lengthiest constitution in the world? The lengthiest constitution in the world, written constitution, will be of Indian constitution. Now, when the constitution was adopted in 1949, to be more precise, let's write the date, 26 November, there was 395 articles. And 8 schedules and 8 schedules and 22 parts. Now, as of in 2026, there are 470 articles, then 12 schedules and 25 parts. Now, there will be minor questions may be asked. A simple question: how many schedules are there in the Constitution of India? And the answer will be 12 schedules are there. How many articles will not come? How many parts in the Constitution of India? There are 25 parts. So now the question is, why is the lengthiest constitution? There must be a reason. There must be a reason to the Indian constitution be a lengthiest question. Lengthiest constitution. The answer to this question is, first point, being a lengthiest question is a geography. See, India is a geographically 7th largest country in the world. There are different dialects spoken. In the south, the different dialogue. In the north, there will be different dialogue. In the east, there will be different dialogue. In the west also. And there are different kinds of people. So since there is diversity in the geography and the people, there must be something for that particular groups of people. That's why it became a lengthiest constitution. Now the second point is historical factors. What is historical factor which can be seen? See, British government in 1935 Government Act, Indian Government Act was initiated in 1935. It was a bulky act. It contains of different spheres in which the administration of a country should be done. So what it does, the Indian constitution borrowed about 60% of the administrative rules and regulations. Since the Indian Act 1935 was bulky in nature, so 60% will go to the Constitution of India. It will automatically a bulky constitution. And the third is single constitution for everyone. Single constitution. What do you mean by the single constitution? Single constitution means the constitution will be same for the person who is residing in Assam, myself, and that constitution will be same if a person is residing in Kanyakumari. There won't be different constitution, different rules and regulation, different rights to that particular citizen. Now, is there any different constitution? Yes, there's an example. For example, America, the constitution of the center is different than the constitution which applies in the state. They have two constitutions. The constitution of center doesn't match with the constitution of the state. So that's how the single constitution, as they have to mention the rules and regulations about different states also. That's why it became say lengthiest or bulky. And the third is domination of legal luminaries. What does it mean? Legal people. When the constitution was made, when the Constituent Assembly was made to draft the constitution, most of the people belonged to the legal area. So they tried to bring all sorts of provisions into it. So it naturally became say bulkier. Now one more thing, these are the 4 points why the Constitution of India is bulky. One more thing I like to explain to it is that in the Constitution of India, it's not a fundamental thing. Fundamental. It doesn't mean that some small points are given and you have to interpret. No, it gives a detailed descriptive administrative procedure. Detailed administrative procedure. Detailed administrative procedure. If there is some provisions are there, you look into the Constitution of India, there will be procedures how to follow this aspect. So there is a detailed administrative procedure is given rather than only fundamental things. The next salient features of this constitution is drawn from various sources. Drawn from various sources. So after the drafting of the constitution, most of the people started criticizing the Constitution of India. Then Dr. B.R. Ambedkar, who is known as the chairman of the drafting committee of the constitution, said that we have prepared a constitution by ransacking all the available constitutions at that time. This word ransacking is very important. Ransacking. Now this may come, who said that I have prepared the constitution by ransacking all the constitutions available at that time of various countries. Ransacking means you milk the constitution in such a way, you take what is benefit, what is required for your constitution, for your benefit, and leaving out other unnecessary things. In this way, the constitution was prepared. Now the next question is the structure of the constitution. The main structure of the constitution was from Government of India Act, Government of Indian Act 1935. As I mentioned in earlier that about 60% all the provisions were taken from the Government of Indian Act. 60%. Now the next is from where the fundamental rights were taken. Fundamental rights were taken from the American constitutions. American constitutions. And DPSP, Directive Principle of State Policy, were taken from the Irish constitutions. So the question may come in a competitive examination from which constitution fundamental rights were taken. The options will given as Australian constitutions, Irish constitutions, and different two more constitutions. The correct answer will be American Constitution. Now again, one more question will come. The political part of the Constitution. What are the political part of the Constitution? Political part which comprises of legislature and executive. From where this legislature and executive will come? Executive and legislature will come from the British government. British constitutions. Down this, there may be one question also from where the executive part of the Constitution is taken from the British constitutions. Third salient features of the Constitution of blending. Let me write third here. Blending of rigidity and flexibility. What do you mean blending of rigidity and flexibility? There are two types of constitution. One is rigid constitution. What is rigid constitution? There is a special procedure to change or amend the constitution which is known as rigid constitution. You have to follow a specific structure, a specific route, a specific procedure to change it. What is the example of this type of constitution is the American Constitution. Mind you, the American Constitution is also a written constitution. So what is a rigid constitution is of American Constitution where a special procedure is required to amend the constitution. What is flexible constitution? Flexible constitution is British Constitution. British Constitution is a unwritten constitution. What does unwritten constitution means? It is not written. Now British Constitution, as there's a change in laws, simply you can amend the constitution of British. Now what is Indian Constitution? Indian Constitution is a blending of rigidity and flexibility. It is not as rigid as American and it is not as flexible as British Constitution. Now, one of the important thing I like to inform you is that the Parliament can amend flexibility. The Parliament can amend the Constitution under which article? Article 368 of the Constitution. It is very important. Under which article the Parliament can amend the Constitution? 368. Now the question arises, is the Parliament can change the whole structure of the Constitution? No. The Parliament cannot change the whole structure of the Constitution. It can change the provisions of the Constitution but not the whole structure of the Constitution, as it is seen in the Kesavananda Bharati case. Kesavananda Bharati case in 1973. Thank you for watching this video. In this video, I have mentioned 3 salient features of the Constitution. In the next video, I will try to complete all the salient features of the Constitution. Then I will move to the another question. Thank you for watching. Appreciate it.